Hey everybody, how's it going? Welcome back to Copper Jacket TV. So we've got a big one for you today. The Ninth Circuit Court of Appeals just heard oral arguments in Miller v. Bonta yesterday. If you don't know what that is a challenge to California's so-called assault weapons ban. Now, this was one of the most interesting oral arguments that I have ever seen. The Ninth Circuit Court of Appeals, this three-judge panel, at least two of the judges didn't even seem to know really what they were talking about at all. I mean, here's proof.
A lot of material in the record about other characteristics of the A-15s. That's what we're talking about, right?
Now, I don't know about you, but I have no idea what an A-15 is, but I assume that they should know what they're talking about since they're dealing with a constitutional case here. So today, we're going to break down the oral arguments. We're going to take a look at California's side. We're going to take a look at the plaintiff's side who are trying to overturn California's law, and we're going to talk about exactly how the Ninth Circuit has set this up so they can basically screw you guys over in California once again. Let's get to it. Now, real quick before we get started, if you guys like content like this, hit that subscribe button. It's free. It only takes a second, but it really does help us spread our message, and it lets the powers that be know that people want to see content like this. And if you're interested in updates on this case as we move forward, hit that little alarm bell. That'll let you know when new videos come out. So with that being said, let's get to it. Okay, so let's go ahead and talk about what's going on here. So we're going to start off with California's attorney and California's argument, because California's argument is that these so-called assault weapons are too similar to something that's used in the military, and therefore they are not protected by even the plain text of the Second Amendment. So California doesn't even believe that they need to go even a step further and provide any type of historical analog to this law, because again, they're just not protected by the Constitution.
The Supreme Court has repeatedly told us that certain types of weapons are not entitled to Second Amendment protection and may be banned, including the M16 rifle and the like. In this case, plaintiffs are challenging 8 defined categories of assault weapons that are banned because of the dangers they pose to the public. Those weapons configurations are defined by certain tactical features and accessories that make those weapons offensive military weapons and not weapons of ordinary self-defense.
So you can see right there that the state of California does not believe that these are protected even by the plain text of the Second Amendment. Now, what's really interesting here is that right after the attorney for California made that statement, he was interrupted by one of the judges in this case, and that judge kind of opened up Pandora's box and allowed us to see what might be happening with Miller v. Bonta. This is really interesting, and this is where I feel that Californians who believe in the Constitution just absolutely are going to get demolished because he makes a comparison between Miller, which is what we're talking about today, and Duncan, which is California's ban on magazines that can hold more than 10 rounds. And so I want you guys to hear this, because I think that this is pretty much exactly what's going to happen in this Miller case.
Okay, counsel, but before you get further into the merits of your argument, can I ask, and I'm going to ask your friend on the other side the same question. What is your view of the relationship between this case and the Duncan case pending before an en banc panel of this court?
So we think the cases are highly related. They involve very similar evidentiary considerations, the same Bruin standard. The plaintiffs even viewed the cases as related when they filed their notice of related cases at the commencement of this case in the district court to relate this case to Duncan.
So do you think, do you want us, what do you want us to do based on that observation? I mean, should we hold this case pending Duncan, or should we go ahead and, what's your view?
So we wouldn't object if this panel wished to hold this case pending resolution of the Duncan en banc proceeding, given the similarities between this case and Duncan.
So that's kind of interesting, right? They're asking the attorney from the state of California, what do you want us to do? We have two cases here. We have Duncan and we have Miller. They're both similar cases. They kind of challenge the constitutionality of these laws under the Second Amendment using Heller, using McDonald, using Bruin. And so these two cases, which are currently both sitting at the Ninth Circuit Court of Appeals, have a lot in common. What do you want us to do about that? And the attorney comes back and says, yeah, I feel that there's a lot of commonalities, and California has proven that what we're doing is constitutional. And of course, he's going to say that. But basically what they're saying in the Ninth Circuit here is, do you want us to wait for an outcome in Duncan before going any further in this case? So basically, do you want us to put this case on hold pending Duncan. Now, the problem with that is that we've already seen the Ninth Circuit Court of Appeals play games with Duncan. We know where the Ninth Circuit is going to land on Duncan, and it's not going to be favorable for us. At least that is my personal opinion after seeing everything that has happened with Duncan. So I don't think we're going to get a favorable outcome in Duncan. And so if that's the case and they wait for Duncan, what happens is Duncan gets a non-favorable outcome for us, right? Then they come back to Miller and they say, based on the outcome of Duncan, we're also going to find in favor of the state of California in Miller and just simply brush this case off. So we're seeing delay after delay and the court like kind of breaking its own standards and rules in Duncan. And then the delay is going to continue. And then finally, they're going to find Duncan in favor of California, and then they're going to apply that to Miller. That's how I see this whole thing playing out. But I mean, by all means, let's continue.
So your position is that this would be, I mean, these kinds of weapons would be outside the original public meaning of what a bearable arm is.
That's correct, Your Honor, because these are military weapons. These are not weapons of ordinary self-defense.
But when we look at Heller, right, so it starts with, they've got, Dr. Johnson and some of the other 18th century dictionaries that just define arms as weapons, right, which these clearly are. And in Heller, it was common ground that everybody agreed that it at least applied to weapons you would use in militia service, and then the question was, does it also apply to other kinds of weapons? As I read Heller, there wasn't really any question that weapons that would be used by people in the military would count as arms. Was there?
So at the founding in 1791, when the Second Amendment was ratified, the Supreme Court observed in Heller that the same weapons that were commonly kept at home for ordinary purposes like self-defense, those were the same types of weapons that militiamen brought to muster. But over time, because of technological advancement, certain weapons have fallen outside of the scope of the Second Amendment.
Now, I'm sure you guys caught that, but what California is basically saying here is that because of certain technological advancements, these are no longer protected by the Constitution. Now, what's interesting here is that other technological advancements have happened that have implications to other constitutionally protected rights, but I don't see anybody saying that those technological advancements mean that they're no longer protected. For instance, our founding fathers could have never envisioned that we would hold a device in our hand, the size of our hand, about the thickness of our hand, that could be used to convey free speech and information. They would have never been able to envision that we would have something called the internet or television or anything else like that. So that right there shows you that they're treating the Second Amendment like a second-class right, exactly what the Supreme Court said that you are not allowed to do. So California's argument is just absolutely it's about as out there as you can get. Now, before we move on to the attorneys for the plaintiffs, so the attorneys for Miller in this case, I want you to hear something that is extremely troubling to me from the state of California. So the attorney from the state of California is asked, again, by one of the judges in this case, whether or not California can ban all semi-autos. And the attorney never says, no, they can't.
Is it the state's view? I mean, in the state's view, could you prohibit all semi-automatic firearms? I mean, I realize that would be considerably broader than the statute you have, but would that be permissible?
It would be substantially broader than the law we're developing or defending in this case and the record that we've developed in this case. It would depend on the record assembled, but the statute we're defending here...
Well, I mean, what in the record would it depend on?
It would depend on the types of firearms that would be subsumed within that particular type of regulation. I'm not standing here today. I cannot say that the state of California would be able to ban all semi-automatic weapons or all
What is the definition of a semi-automatic weapon?
Okay, so now that your brain has been turned to mush after listening to that, let's go ahead and move on to the plaintiff's attorney in this case, which does, I mean, this guy does a fantastic job arguing the points in this case. But one thing that he has to contest with is a judge which clearly has no understanding of the actual topic at hand here. And you could tell that when she says this.
With a representative government in this country, presumably, an item that a substantial portion of the population believes is effective for lawful purposes, a ban of that item is not going to be able to be maintained for long periods of time across broad swaths of the country. And that's what we see here. These firearms have not traditionally been illegal in this country, as the Supreme Court itself held.
Well, they haven't
in the
traditionally
Staples
existed.
case.
As I understand it, they basically were created during World War II. Was that not true?
These specific firearms in the 1950s and 1960s.
So now we can see that at least one of the judges doesn't know how they function, what they are, and or when they were actually created. So this is a really interesting dynamic that we have here with two very liberal judges and one conservative judge. Again, totally outnumbered. The conservative judge is outnumbered, which leads me to believe that this is all going downhill and this is all going to end very, very badly. But again, I just wanted to point out here that they don't even know really what they're talking about. Now, I'm going to spare you the rest of that by just summarizing for you what happened. The court basically pushed back on pretty much everything that the plaintiff's attorney said and tried to disprove every fact that the attorney brought up. It was completely one-sided. It was a complete attempt to, almost discredit everything that the attorney was saying. And it was really kind of difficult to watch, to be honest with you. But I will put a link down below to that video where you can watch it for yourself. It's about 45 minutes or so. But if you are interested in watching that, by all means do so. California does get up again and tries to make, some arguments. But the plain fact here is that they were so much more friendly to the attorney from California, with only offering minor pushback, and completely the opposite for the attorney for the plaintiff. So I don't see anything good coming out of this, to be honest with you. And the fact that they're kind of leaning on Duncan here, and they mentioned Duncan multiple times throughout this video, it's kind of disheartening. But we'll see what happens. I mean, we follow this. I have been following this since, the day this was first filed. I've been following it since well before that. I've been doing this now in California for about 11 years. Well, close to 11 years now. But I started off in California before I moved here to Nevada, and this case has been on my radar with Duncan and Rhodey and all of the other cases that have been filed since. And I am going to let you guys know about everything that happens here, because we're just not going to stop until we get the outcome that we know is correct, the constitutional outcome in this case. But I have a feeling this one, along with several other cases that we've seen across this country, including in Chicago and New York and places like that, they're going to end up at the Supreme Court. Well, I just believe that this one's going to end up probably at the Supreme Court first. But we'll see how long the Ninth is going to be able to delay this one, like they've been doing in the past. But anyway, I wanted to share that with you. I wanted to break it down for you so you guys have a good understanding of exactly what's going on here, what the arguments are, and what California really and truly thinks of your rights. So anyway, I want to thank you all very much for watching. If you haven't done so already and you've stuck it out this far, first off, thank you very much for hanging in there. Hit that little bell notification. That'll let you know when any updates come out about this topic and several other topics. And, if you haven't done so, just hit that subscribe button. It's free. It only takes a second, but it helps us spread our message. So again, thank you all. Have a great day.